Hello, and welcome to Let's Talk, a Tulsa World virtual town hall meeting. I'm Wayne Green, editorial pages editor of the Tulsa World. Today's town hall is graciously underwritten by the George Kaiser Family Foundation. Today we'll be talking about the recent U.S. Supreme Court decision in the McGirt versus Oklahoma case. Our guests are Oklahoma Attorney General Mike Hunter and Cherokee Nation Attorney General Sara Hill. Welcome to both of you.
Morning.
Thank you.
So normally we base our town halls on questions submitted by our readers, but the timing situation didn't allow for that today. So we'll be using my questions and we'll be getting to as many of those as possible. But first, we're taking this on Tuesday, July 28th. And just moments ago, we found out that the federal judge in Oklahoma City had made a ruling in the litigation brought by the five tribes against the governor concerning whether the agreement between gaming tribes and the state automatically renewed on January 1st or not. Attorney General Hunter, what did the judge rule and what's your response to it?
Well, the judge found not altogether unexpectedly, at least from the perspective of our office, that the compacts renewed at the end of the year pursuant to the automatic renewal provision in the compact, the 15-year term, again based on a condition in the compact, as long as there was electronic gaming at Remington. I mean, I'm being more general probably than I should be. The compact renewed, and one of the things that was important as I, attempted to help people assess the ups and downs, the pluses and minuses of the position that they didn't renew, is that you have to look at the circumstances back in 2005 when the focus of the state was to make sure that the track was going to be viable and that our horse racing industry would be preserved as a result. So that was the consideration. That was the focus back then. Gaming was really a secondary consideration. It's certainly grown into the most paramount concern with respect to the compact. But I've always felt like it was drawing to an inside straight to take the position that they didn't renew. And so where we go from here is there's certainly an opportunity here, I think, still to sit down with the tribes and focus on what can be done to improve their gaming opportunities so that they stay competitive with other states and so that the state can benefit from that. So where we go from here is it's important to, again, approach this on a more conciliatory basis. That was what I was trying to do last fall. Before the governor made a decision to, again, hire an outside firm. And my position was, if he did that, I had to withdraw from the negotiations.
Mm-hmm. Attorney General Hill, first, congratulations. This sounds like a big win for you and the Cherokee Nation. Is this the last question to resolve here, or the most important question? I mean, are there still issues at large?
I think this was the issue. This was the primary legal issue, and both sides, submitted to Judge DeGiusti, cross motions for summary judgment. Basically, both sides agreed that there were no questions of fact that needed to be decided by the court, but really just a question of law, which was, what does this language in the compact mean? And we felt confident from the beginning that all of the conditions had been met for the compact to automatically renew, and that interpretation of that compact language is really the only issue the court had to decide. So I feel like that the issue has been concluded. Now, that doesn't mean there won't be other motions filed in that case, or that it's not possible that the governor may decide to take an appeal. So I don't know if every issue is completely done, but that was the key legal issue that between the state and the tribes was, what is the meaning of this language in the compact regarding automatic renewal? And now we've got a clear answer to that question from Judge DeGiusti.
So let's turn now to the McGirt versus Oklahoma ruling from the U.S. Supreme Court recently, and first you need to build a little bit of background on the case. Attorney General Hunter, the case is unusual in a lot of ways. It included two different named appellants and two separate arguments before the Supreme Court and an awful lot of waiting. Can you briefly describe for us the road that led up to the ruling?
Well, originally, a convicted murderer named Murphy began the Supreme Court's review of this process. And, I'll try to give you the Reader's Digest condensed version. His argument in this district court here in Oklahoma and to the 10th Circuit was, my conviction is invalid because the state didn't have jurisdiction over me. I'm a Creek Indian and my crime occurred on reservation lands, and that reservation lands locus, if you will, took me outside of the jurisdiction of the state because the reservation of the Muskogee Creek hadn't been disestablished at statehood. So there was what we believed to be a 4-4 tie with the court, the Supreme Court, when it was argued over a year ago. They took a different case, a case that was brought before them from an appeal from the Oklahoma Court of Criminal Appeals. Mr. McGirt sexually assaulted his girlfriend's granddaughter and was in prison for that. So almost the exact same argument, no jurisdiction, because I'm a tribal member and the crime occurred on historic tribal lands, which are a reservation that existed and persisted after statehood. The Supreme Court found, and I'm going to editorialize here a little bit, the Supreme Court's decision wasn't altogether expected in the sense that it favored the tribes. What I object to and what I'm disappointed about, and I'm only speaking for the state, is the flash cut method that was used by the majority to make the decision. So 113 years of jurisdiction with a stroke of a pen was absolutely set aside by Justice Gorsuch, who wrote the opinion. And I think that's irresponsible. That's the biggest challenge that both the state and specifically the Muskogee Creek have. How do we quickly adjust jurisdiction? How do we ensure there's not a public safety slippage? Because the impact of the decision is that the state loses criminal jurisdiction over any crimes that occurred that involve a Native American in the Muskogee Creek Historic Reservation. And we're talking about, of course, most of Tulsa County, and then the 5 or 6 counties sort of below, left and right, adjacent to Tulsa County. So I want to report that so far there's been hard work and cooperative effort, both with regard to local law enforcement and the Muskogee Creek, but it's really a challenge. How do you make decisions about jurisdiction in a thoughtful way? How do you ensure that there's not a public safety slippage, that an officer doesn't have to worry about whether they can detain somebody, again, based on their status as a Native American? So my biggest objection, again, to the decision is that there was no effort to provide a transition period. Again, I thought, and I think that's reckless and irresponsible. And I guess my precedent is, years ago, the Supreme Court found that the Bankruptcy Act, Federal Bankruptcy Act, was unconstitutional. And what the court did was it provided Congress months to rewrite the bankruptcy code, instead of just overnight saying, well, no, all bankruptcy courts are losing jurisdiction over those cases. So I'm disappointed in that part of the decision. Again, it wasn't altogether unexpected that the decision favored the tribe, but we really have some challenges, particularly on the law enforcement front in front of us.
So Attorney General Hill, as Mr. Hunter said, we finally got a ruling in the case here recently, and the court was pretty sharply divided. Justice Gorsuch and 4 justices are normally sort of thought of as the liberal wing of the court ruled for Mr. McGirt and the tribes that had intervened, and Chief Justice Roberts and the 3 most conservative members were in the minority siding with Oklahoma. How would you describe what the court ruled?
I think from a tribal perspective, the ruling said a lot of things, and I think that it's fair to say that it was unexpected, because I think Indian tribes have gotten used to the Supreme Court finding ways to cut around tribal sovereignty, to find ways to find exceptions and exemptions so that tribal sovereignty doesn't exist, even though the United States promised the tribes that they would have sovereignty over their territory. And I think a lot of people in Indian country are always nervous when the Supreme Court takes an Indian country case, and to pull open the Gorsuch decision and see at the end of the Trail of Tears, there was a promise like that. Those words are impactful to the tribes because those promises were made. And I think Indian country had lost hope that those promises would be kept, that the United States Supreme Court would require that those promises be kept. So, from the tribal point of view, to see, those words on paper, that, yeah, those treaties had meaning, those words had meaning, and the United States will be held accountable for keeping their side of the bargain at any level, was a shocking result to me personally. It took me rereading it several times for me to understand what Gorsuch, that he really said what he meant, and meant what he said in that ruling. And I think, and leaving aside some of the practical concerns that the Attorney General for Oklahoma raises, concerns which I think are, concerns that need to be discussed. The tribes never, the 5 tribes received their territory in fee patent from the United States in exchange for their lands in the East, which had been theirs, since time immemorial. Those lands had belonged to the Cherokee Nation, and in this case, the Creek Nation. And they exchanged those lands for lands in the West. And that exchange and that promise from those treaties, the tribes themselves, Oklahoma, when it became a state, a lot of those promises were broken. The treaty said that no tribe, none of the 5 tribes would ever be made part of any state. That treaty promise was broken. It said that the tribal lands would be held in fee, which is absolute, complete tribal ownership. But those lands were allotted and were split up into these different parcels, which eventually went into non-Indian ownership. But the court did say in its opinion that what Congress hadn't done is Congress had never said that the reservation of the Creek Nation had been disestablished, because we know that sovereigns have, Oklahoma has boundaries. Oklahoma exists as a place, and the Creek Nation exists as a place as well. And if Congress intends to disestablish those boundaries, and it intends to take away the meaning behind the promise made in that treaty, it's going to have to do so explicitly. The Supreme Court is not going to do Congress's dirty work for it. And Congress had never explicitly said that those boundaries had disestablished, or that the Creek Nation's place had been taken away from them. And so to see that reaffirmation of at least some part of that promise, that the reservation of the Creek Nation was intact, that it still had boundaries, and those boundaries still had meaning under the law, that was pretty important to the tribes. And I also think, if you read the opinion, you see Gorsuch wrestling with what does this really mean for the tribes if they still have these boundaries intact? What does that mean for? Should that meaning change? Should those boundaries be disestablished because Tulsa's there now? Is that something that changes the nature of the promise that was made in the treaty? Is that something that just the character of that changing, does that change the plain meaning of the words in that treaty? And I think Gorsuch, took that pretty much head on and said, I'm not going to decide just because the nature of the land has changed and because the population has changed that those promises that were made don't matter anymore. And so all of those things, I think, make it an important Indian country case. I certainly acknowledge and understand Attorney General Hunter's concern about law enforcement, because law enforcement in Indian country is complex, and it's going to take a high level of collaboration, a high level of it's advanced intergovernmental cooperation. It's going to be required between the tribes and the state to make this work for all of the citizens who live in Oklahoma and love this place and call it home. And I think that the tribes and the state are very capable of that. I think we've demonstrated that we're very capable of that.
Let me ask one clarifying question here. You made reference to a treaty that said that the 5 tribes would never be part of any state. Of course, treaties, the history of the tribes and treaties, as if there were series of series of treaties that would come on top of one another and break the promises of the previous treaty in most cases. But one of the potentials of this is not the fact that Oklahoma could go away as a state because the 5 tribes were promised in the treaty that they would never be part of a state. Am I correct?
You're correct. And I think, Congress has, what we call plenary authority over tribes. Congress can break its promises, and it has broken those promises many times. And one of the times it broke that promise to tribes was in the creation of the state of Oklahoma. But it did so explicitly. It specifically said Indian Territory is now part of the state of Oklahoma. And it broke that promise, but it did so by explicitly stating that it had broken that promise. And breaking that promise to the tribes did not break every promise that was made. And that was, I think, what Gorsuch was saying. If Congress intends to break a promise that it made in a treaty, it must do so explicitly. It must say very clearly that this promise is broken.
No, thank you. I understand that completely. Attorney General, Hunter, let me throw 2 questions at you at once. First, just on a factual basis, how many criminal cases are we talking about here in Oklahoma? But then in a more general sense, when the likely scenario here is that cases that were convicted in Oklahoma criminal courts will now go to probably federal criminal courts for retrial. But when you retry a criminal case, there's all sorts of things that can happen. Witnesses disappear, evidence disappears, memories change. Do you see a lot of people who are currently in prisons eventually being freed because of the McGirt decision?
Well, it's a reality that we're wrestling with, and I'm done with my indictment of the McGirt opinion and Justice Gorsuch. Where we have to go from here is concurrently we've got to deal with the challenges of losing jurisdiction in the short term, and simultaneously, as has been reported, continue to work with the tribes to fashion a congressional remedy to some of the uncertainty and some of the issues around jurisdiction that we all agree exists. So with respect to convictions, as far as I'm concerned, that's the most unfortunate part of the opinion as we look at it both now and in the future, because there are somewhere between our estimate, and this is an estimate, of 1,500 and 2,000 people currently incarcerated, convicted of crimes that they're paying, their debt to society as a result of. And the federal government can certainly, if those convictions are overturned, the federal government can choose to retry those cases. But your remark about the consequence of witnesses' memories and evidence being stale is certainly something that we're concerned about as we attempt to ensure that there's not a public safety result that's negative to the public with regard to all these people whose convictions may be overturned. So there's some practical considerations for inmates. Are you better off having your case retried in federal court where you could get a result that's more of a punishment than the one you have? Where are you in your sentence? There's no requirement that the federal government give you credit for time you've served in state prison. So we're hopeful that, again, the issue of appeals from convictions begins to become a manageable one. But I want to underscore the effort that's gone on with the tribes in the state in a thoughtful, well-informed way. We had the best minds, as far as I'm concerned, in the country, Wayne, around the table, looking at these issues, people that have lived Indian law for decades and decades. And so what, again, we tried to do was to come up with a proposal that we've agreed to for Congress to consider and wordsmith into a bill that restores criminal jurisdiction to the state going forward, and at the same time addresses some of the uncertainty about jurisdiction on the civil side. So that's our approach in the near term, and we've got certainly challenges here, but we're rolling up our sleeves. And I know I speak for law enforcement in that part of the state. We're going to do what we need to do to protect the public, and I know the tribes feel the same way.
Attorney General Hill, 2 sort of backgroundy sort of questions again. There's been a broad assumption that if the court found that the Creek Nation reservation had never been dissolved, that the same must also be true of the Cherokee, Choctaw, Chickasaw, and Seminole Nation reservations. Is that your working assumption? And can you help us understand why this doesn't seem to apply to the western half of the state as well as the eastern half of the state?
Well, I mean, certainly the decision handed down by the court on the issue regarding the court's interpretation broadly of how promises must be explicitly broken by Congress, all of that applies broadly in Indian law. So I think that the Supreme Court opinion applies, it'll take time and decades for people to determine exactly what the impact of that is going to be. But we do know, a decision about whether or not a reservation has been disestablished is a factual one. They look at the facts. What the language did Congress use when it did allotment? What language did Congress use? What language was in the treaty in the first place? What laws were passed that were, so there's a lot of difference, a factual determination. The broad assumption that it will apply to the rest of the 5 tribes is because the 5 tribes share a very distinct legal history. A lot of the allotment agreements have word for word the same language from one tribe to the next, or very close to word for word language. The treaties that the 5 tribes signed are in many sections word for word from one another. So because of the extremely similar legal history, the history of the removal, the history of the acts of Congress, the fee patent nature of tribal land ownership among the 5 tribes, the shared legal history means that the conclusion that Gorsuch reached in the Creek Nation is likely the decision you will reach for all 5 tribes. So that's the short version. It's a fact. It has to do with the facts of each tribe's reservation and the facts surrounding the acts of Congress that affected that reservation. And so it's not that it doesn't apply to other tribes, but other tribes have different facts. So if you take another tribe in the western part of Oklahoma, their allotment agreements are not going to be identical to the ones in Creek Nation. The acts of Congress that apply to them are going to be slightly different. Their treaties may have very different language. Their land holdings may be very different. So it's not that it wouldn't ever apply. The same test, the Solem test that the court applied with the Creek Nation still applies, but it's because of the same facts. And it's best analogy I have is sort of the flag burning law that was on the book in many states, had laws that made it a criminal offense to burn a flag. Well, then the Supreme Court hands down a case that says that you can't criminalize that. That's a violation of the First Amendment. Well, you didn't have to go in and strike down every individual state law, right, that said it was a crime, because it was clear that it was a crime, because the facts were the same. The law was the same everywhere. And so it has to do with the facts and the law being the same in the 5 tribes as it is in other places.
So at one time, the Cherokee Nation went west all the way, I think to the, if I'm not mistaken, all the way to the Panhandle, the so-called Cherokee Strip. Was that a situation where the land ownership was specifically broken by a superseding treaty?
Those lands were ceded in other treaties. So the Cherokee, the 14 county footprint of the Cherokee Nation is the footprint of the Cherokee Nation today. The Cherokee Nation at one time had much larger land holdings in Oklahoma, including the Cherokee Strip. The land that's now the Osage Nation was sold to the Osage by the Cherokee. So over time, the Cherokee land holdings by sale or by cession were contracted down to the 14 counties, which is the footprint of the nation today.
Okay, so let's drill into the implications of the ruling a little more, and staying with you, Attorney General Hill. Does the ruling have any implications on things like adoption of Native American children or taxation of Indian nations or of their employees?
So the McGirt decision, Gorsuch's decision, on the one hand, he very specifically says this decision is limited to the Creek Nation. We're talking about the Major Crimes Act. And he says there may be other civil implications because there are many civil laws that refer back to the Indian country definition that is in the law. So he knew that there were other implications, but he wasn't deciding that. The court doesn't decide issues unless they're directly in front of it. So Gorsuch didn't say it's going to apply in these different circumstances, but as a practical matter, people who practice Indian law understand that there are other implications. And one of those, probably the most clear-cut one, is in the Indian Child Welfare Act, which says that Indian children on Indian country are under the exclusive jurisdiction of the tribe. So if a child, for child custody proceedings, which are all defined, all of this is really complex. It's hard to boil it down to a soundbite, but it definitely will have, in the absence of other agreements between the state and the tribes, it would say that an adoption petition for an Indian child would have to be filed in front of the tribal court, couldn't be filed in the state court. But the law also provides, the Federal Indian Child Welfare Act provides for states and tribes to reach agreements on jurisdiction. So those are things that the tribes and the state by agreement can enter into, and then share jurisdiction over those. So those are not, that particular problem is one that can be solved with good tribal state cooperation and without requiring anything of Congress.
The Indian Child Welfare Act is a federal law that stipulates how Native American children adoptions can be handled in what is known in law as Indian country. It's a legal term that was specifically, the Gorsuch decision says that at least the Creek Reservation is now, for legal purposes, Indian country. Am I correct?
Yeah, Indian country. And
okay.
there are other implications, I think, from that. There are a lot of different, federal laws that refer back to that. And so one Indian country, these different laws will operate differently. Tribes, jurisdiction over their own reservations, the jurisdiction that tribes have over their own citizens living on the reservation is different in Indian country than off of Indian country. So there are a lot of implications, and I think sorting through those, with the state, and there are going to be, I'm sure there's going to be some litigation about some of these issues as people. Because in the McGirt case, the Creek Nation did not ask the Supreme Court to put their reservation issue. They didn't put their reservation issue in front of the Supreme Court. Mr. Murphy did in his criminal case because it would benefit him. It wasn't up to the tribe to determine that. And I think that there are other contexts where individuals will see some advantage and they'll say, I want to get this issue in front of the court because of some advantage to me. The tribes may or may not have any control over how that's handled. I think that's why tribal state collaboration is important. So that the people who have an interest in public safety, who have an interest in stability, in how things are done in the state, are having those conversations, or not leaving that up to people who are litigating for their own purposes.
Okay, so you didn't answer half of the question I originally asked, so I'm gonna hold your feet to the fire a little bit. Is one of the possible implications that the state of Oklahoma can apply an income tax against employees of the 5 tribes?
I mean, there is a specific issue about income tax that's going to have to be dealt with. Yes.
Attorney General Hunter, do you agree with what she said here?
Well, there's definitely going to be an increased deference to the tribal governments and to tribal businesses and employees of those tribal businesses. But it's the position of the state that tribal members within the reservation lands will continue to be subject to state regulation, will continue to be subject to taxation. Of course, the hope is, with regard to the agreement that we're working out, that we're going to have shared criminal jurisdiction with the tribes and the federal government. The goal of all this, Wayne, is we can't have a situation where the tribes, their members, the importance that they have to the state's history, to the state's economy, we really just can't have any space there with regard to how we on a daily basis interact as the state, as tribal governments, and as whether you're a member of a tribe or not. We've got to ensure that there's not uncertainty, that commerce can move in a way that benefits everybody. And at the end of the day, what I like to say about this agreement, which is an agreement that is in the nature of a proposal to Congress, is that we can come away after Congress acts and after this opinion, and tribal members can view their membership in their respective tribes with dignity and honor and be proud of that. But at the same time, they can be proud and they can be in a constructive and productive way. And I mean that both with respect to how they benefit and how the state benefits citizens of the state of Oklahoma. So that's my goal as the Attorney General for both tribal members and non-tribal members. And I think it's a good headline for the proposal that we're going to be working with Congress to see if they can finalize.
Does the ruling also shift the power situation in non-Native adoption of Native American children?
So there are efforts underway. And we've worked closely with the tribes. And I want to signal that We're very hopeful that there can be compacts to ensure that the Indian Child Welfare Act and the jurisdiction and oversight can be shared with the state through the Department of Human Services. So we're hopeful that those can be compacted here in the very near future. We've gotten good, strong, positive signals from the tribes that that's a goal that they're interested in. And I think it makes sense. It certainly makes sense for the tribes, the state, as well as individuals covered by the act.
There's a lot of fear out there that the logic of the McGirt ruling could somehow undermine property rights in eastern Oklahoma. Is there a danger that landowners in Tulsa could somehow have title of their land be thrown in doubt by this Attorney General Hunter?
So I was a property lawyer for a number of years before I devolved into a public official. My view of that is that property rights are unaffected. And I think that's a view that I'm confident about, and I want to signal that to folks. I don't see any theory under which title to real property, oil and gas leases, and contracts that are in place are affected.
Attorney General Hill, do you agree?
I do agree. I agree with that. I think that property, then I know there are a lot of people who have concerns about property because people in Oklahoma don't have a good sense of what a reservation is or what it means. So they think, well, this must mean the tribe owns all the property in its reservation. And that's not what it means. It has more to do with governmental authority and jurisdiction. I did want to follow up just briefly on one comment a question you asked Attorney General Hunter, and I want to answer it as well about tribal adoptions and non-Indians adopting tribal children. The Cherokee Nation has a well-deserved reputation for working hard to ensure that Indian children are placed with their families or in tribal homes. And we will use whatever tools we have at our disposal to continue to ensure that happens. And I think that this does strengthen our ability. Do we need Oklahoma and do we want to continue to work with Oklahoma? Does there need to be jurisdiction sharing? Yes, but I also think it does strengthen the tribe's ability to ensure that Indian children stay with their families, and that if adoptions occur, that those adoptions occur with members of their families or with members of their tribe. And that remains as important a goal to us as it ever has. And I do think that the McGirt decision strengthens our ability to do that. And that's something that's important that we maintain.
That's right. The Cherokee Nation has been very aggressive on this issue long before the McGirt decision. And
right.
I didn't mean to not say as much. So I'd like to give both of you a chance to describe what you think the next step in the process would be. You've already kind of talked about this, Attorney General Hunter, but let's go over it again if you don't mind. Are we headed to some sort of resolution involving congressional action or perhaps more agreements between the state and the five tribes? Or is this going to be a matter of enormous litigation, the Full Employment Act for attorneys in Oklahoma? Let's start with you, Attorney General Hill.
I mean, I think, certainly we have been working hard with the Attorney General, and the agreement in principle that we laid out, walked through some of the things that we think are necessary. We know there's gaps in criminal jurisdiction that only Congress can really close, and going to Congress is essential. That's something we'll continue to work with Attorney General Hunter to do. I do think, Congress, that the Oklahoma congressional delegation has an interest in seeing that those jurisdictional gaps are closed, and so do the tribes in the state. That's one thing that we could always agree on, General Hunter and I. Everything else aside was that when it comes to public safety, we have the same feelings about that. We prosecute the Oklahoma Attorney General's office, the Cherokee Nation Attorney General's office. We prosecute criminals and we protect public safety, and that's our goal. And to that end, we're willing to work together. We're willing to go to Congress to get what we need to close those jurisdictional gaps. So I think that effort is going to continue, and certainly, we're committed to that. There are a lot of issues raised by McGirt. This case hasn't been decided just over 2 weeks now, I think. And so there are still a lot of discussions that we have to have about a lot of different issues that are raised, and a lot of different stakeholders have different ideas about what might happen. And at the end of the day, I don't control what Congress does, neither does General Hunter. We can only make recommendations to them that we think make sense for all parties. And I think that Oklahoma, at the end of the day, is going to be stronger because of McGirt, because the tribes' jurisdictions have been affirmed. I think that we see a win-win here, where Oklahoma is made stronger by the tribal governments being able to operate and continue to operate in a robust way and to have their boundaries affirmed. I think that this could be a win-win. I think we have the capacity to do that, but that means that we have to work together to ensure that people like Mr. Murphy and Mr. McGirt get justice. And all of the other people who committed crimes against individuals in the state get justice as well.
Just to say explicitly what I think you essentially said a couple of times in the conversation today, this is an issue that Congress can, if it chooses, have the final word on. This wasn't a ruling concerning Bill of Rights, civil rights, or anything like that. This is essentially an issue of statute and treaty that Congress can just resolve one way or the other if they choose to. And
right.
The politics of that are peculiar because it's strictly, I mean, this is an issue that's really only about Oklahoma. This doesn't have broad application to the other 49 states. And from just a political perspective, it's kind of hard to imagine that a lot of congressmen would be looking to disaffect their Native American populations in their own states by taking some sort of aggressive step that would be read as anti-sovereignty. Do you agree with that analysis?
One would like to think so, but I do think it's important for everyone to understand that Gorsuch never said that the reservation of the 5 tribes could not be disestablished. He only said that Congress must explicitly do so if it intends to do that. And I think that's something that Indian country understands, because Congress has disestablished reservations explicitly throughout its history. And there have been cases where when tribes have greater authority in some area due to the law, that Congress goes in to change that, to reduce that authority, to put limitations on that authority. There are many examples of that in Indian law. The Indian lawyers who do this appreciate and understand the peril that Indian country is in all the time from Congress. And that's why it's important to have a seat at the table and be sure that our delegation, when they're discussing these issues, they understand what's important to us, because we do understand that, and I think you're right, why would the delegation want to take a negative action that would anger its constituents? But they're not all of Congress either, and there are lots of different forces at work here. So I think that's why collaboration with Attorney General Hunter is critical. Identifying those areas with which there are broad agreement, like we did in the agreement in principle, is important, and working with our delegation and making sure that they hear from us what it is that we think is important, because we know that Congress does have the power to disestablish reservations should it ever choose to use it.
Okay. Attorney General Hunter, turning back to you, what do you see as the road ahead from here?
Well, we've got some near-term issues that are practical, that have logistical challenges that I think I've mentioned. I'm committed, and I know I speak for law enforcement around the state, particularly in the Muskogee Creek Nation, where we've got the most immediate concerns and exigency with regard to ensuring that there's not slippage with regard to public safety. So I feel like we're making progress there. There's still a lot to do. I'm concerned about it, but the good news is we're talking, and that we're making progress towards, again, how we kind of put a tourniquet on this jurisdictional deficit that we've got, at least for the time being. I'm optimistic that the Muskogee Creek leadership and the Seminoles will come back to the table, and that we can present a united front to Congress. As I've said recently, it's been my experience that the best thing to do is frequently the hardest thing to do. The right thing to do frequently is something that is very, very difficult. And I know that there are challenges that exist with regard to criticism of the approach that this agreement takes. But at the end of the day, those of us who are around the table, those of us who have to manage the consequences, what the world looks like after McGirt, we have to deal with the practical concerns as regards governance. We've got to make real hands-on decisions every day with regard to public health and safety. And the agreement that we have in place allows us, both the tribes and the state, to discharge our responsibilities to our constituents. And I'm hopeful, optimistic that we're going to be able to lock arms, present this to Congress, and it'll move quickly. And we can have the certainty that we need to collaborate, cooperate, and have the relationship, the government-to-government relationship that is in the state's best interest and in the tribe's best interest going forward.
So maybe you can clarify a suspicion that I've had for a while here. That, you know, immediately after McGirt, you had a press release with the 5 tribes that outlined a mechanism for resolving a lot of the issues that came from McGirt. But then very quickly, 2 of the tribes, the Seminoles and I'm not now I've forgotten, is it the Chickasaws, I think, said no, that's not.
Well, the Seminole and the Muskogee Creek, for the time being, have withdrawn from
right, and
principle.
Some of the other tribal leaders have sort of put the agreement in principle at more of an arm's distance relationship in some of the things they've said. Is part of what they were concerned about, in fact, what was just resolved today by the federal judge was the failure of the state and the tribes to come to an agreement on the issue of gaming compacts, part of the issue of resolving the McGirt issue?
I mean, I think those are really unrelated. The gaming compact issue is really it's a compact, and the legal dispute with the governor's office was really over. I mean, it was a legal dispute over what this language in this compact meant. And regardless of whether there's a reservation or not, in order to conduct Class 3 gaming, there has to be a compact between the state and the tribes. So I think that is really separate. I think, you know, the reason I think you've seen so much discussion, I can't speak for any tribe but my own, but I know that in the Cherokee Nation, you know, the Cherokee Nation is a robust democracy. Everybody wants to have an opportunity to say what they feel is best for the tribe. And there has to be some space to have that discussion with elected leaders. And I think all of the elected leaders of the Cherokee Nation are listening to what everyone has to say about, you know, and also it takes time to explain what does McGirt mean, just like there are non-Indians who felt like, well, now I live on a reservation and so does my land belong to the tribe? Like there are people that have those questions. There are Cherokees who are asking, well, since this McGirt case is over, I mean, am I still an Oklahoman? Do I still vote in elections in Oklahoma? What does this mean now that there's a reservation in Oklahoma? So there's a lot of education that has to be done so that the people in Oklahoma understand what McGirt meant, what it doesn't mean. Why the tribes feel it's necessary to work collaboratively with Oklahoma on these issues. And there, I think, at least from the Cherokee Nation point of view, giving time and space to have that, to let our robust democracy do its work and to let people both educate and hear back from the constituents of the Cherokee Nation. I think that's why you've seen that it's not that there's any feeling, you know, from my point of view that that we don't need to collaborate with Oklahoma, but it's a question of educating and listening to what our constituents think about what's going on. And this is still an extreme, I've been dealing with this and Attorney General Hunter has been dealing with this for a couple of years now. We've been dealing and wrestling with what these issues will mean for Oklahoma and what they'll mean for the tribes. But a lot of our citizens are still getting their heads around what it means.
Let's resolve that one issue you raised there. Members of the Creek Nation, the other 4 tribes are still Oklahoma citizens. They're still United States citizens. They can still vote in elections. None of their civil rights, voting rights have changed as a result of the McGirt decision, correct?
That's right. That's right.
Okay, Attorney General Hunter, have I given you a chance to answer the question of what I've sort of lost my track here. Have you had a chance to answer the road ahead question here? And do you agree with what the Attorney General Hill just said? Any disagreement there?
I do. You know, I started out to be an historian, ended up becoming a lawyer. History is still something that guides a lot of how I approach decisions that are of this magnitude. And one of the things I know as a student of history is that the record of how the federal government, and in some ways the state early in its infancy. The record of how tribes were treated, and tribal members were treated, is simply put disgraceful. And so where we go from here is there's got to be an approach after this, and I'm sensitive to this, and I think that the success that I've had in dealing with tribal issues speaks for itself. The water settlement with the Choctaws and the Chickasaws, which is monumental and ensures that at least central Oklahoma can have access to those waters. The approach that the tribes took when we got to a point where we knew we could settle that was not only faithful to their responsibilities to their constituents, but it was faithful to the fact that we are all Oklahomans. And I guess what I want to say is, in conclusion, I'm confident that we can conclude all this in a way consistent with Sarah's remark, so that we're all going to be stronger as a result. I don't want to equate the back and forth in the McGirt case to war, but there's certainly an analogy here. The tribes won, there's a victory there, but I'll say this about the people that I've been working with the last 2 years. There's been a commitment to not only winning the war, but winning the peace. And I really feel like that's the goal of the agreement principle, is to ensure that the tribes in the state can win the peace going forward.
Your reference to history is interesting to me personally. I can remember in 9th grade Oklahoma history class, my teacher, a very proud Native American woman, standing up in front of us and saying, there are no reservations in Oklahoma. Whatever else happened with McGirt decision, it certainly made us have to rewrite our understanding of history, and we're going to have to rewrite all the history books too. As we wrap up here, I want to give each of you a few moments to add anything else on the issue that you're anxious to say, but didn't fit in the boundaries of the questions I asked. Why don't we start with you, Attorney General Hill?
Well, I think that I've explained as well as I can the complicated process that brought us here. I will say that I agree about winning the peace. That one of the things that the McGirt case provided, because tribal lawyers have been saying for a long time that there are reservations in Indian country, and nobody listened to that. Nobody believed that that was true. And so there's some sense of vindication here that yes, there are reservations in Oklahoma. Yes, tribes have authority within their boundaries and within their borders consistent with that reservation. But there's also this sense that Oklahoma is a really unique place. And it's something that the tribes value. This place is our home. Fighting with the state of Oklahoma, I am proud to be able to live on the Cherokee Reservation, which I am certain that the courts will recognize, and to be able to be here on my tribe. I'm also proud to be an Oklahoman, and I can finally be both of those things under the law because of the decision in McGirt. And other people will understand, and I can wear both of those things and be in both of those places at the same time. I can be an Oklahoman, I can be a Cherokee Nation on the reservation at the same time. And I think that that's a place that, that we need to get that. One of the things that I think that Oklahomans and Cherokees and other citizens of the 5 tribes that we'll have to learn to really value is that we have to work just like we always had to work together, but that we've gone from maybe intermediate to advanced intergovernmental cooperation in this process, so that we'll have to get even better at communicating, even better at being sure that we're making good decisions for all the parties involved. And I believe, and certainly working with General Hunter's office and with the Solicitor General, both of whom have been excellent to discuss very difficult issues with. I have a lot of confidence that Oklahoma can do this and that the Cherokee Nation can do this.
Attorney General Hunter, final thoughts?
Well, my final thoughts are there's a great it's not really a poem, but there was a fellow named Piet Hein who wrote these little simple, I'll call them ditties, and one goes like this: problems worthy of attack prove their worth by hitting back. So this problem is going to hit back some, but it's worthy of attack. And I guess I just want to convey to those who've tuned in, we've got a handle on this. One of the things I said when this process began was, I'm not going to let it turn into an us versus them issue. And it's not, it's an us issue. And we're going to work through this. And I agree, although it's going to be, there's skeptics out there about all this. We're going to work through this, and we're going to have a better relationship, the sovereign Native American governments and the state as a result of all this. Maybe not today, maybe not tomorrow, but the outcome of this is going to be in everybody's best interest eventually.
Well, thank you. I want to thank our guests today, Oklahoma Attorney General Mike Hunter and Cherokee Nation Attorney General Sara Hill. You've helped us understand a complicated issue of law and history, and I think allay some fears for our viewers. Thank you too to our viewers and to our sponsor, the George Kaiser Family Foundation. Please join us again for our next Tulsa World Let's Talk virtual town hall next week, when we'll be discussing plans for reopening the public schools with State Superintendent Joy Hoffmeister and Tulsa Public Schools Superintendent Deborah Gist. I'm Wayne Green, Editorial Pages Editor of the Tulsa World. Goodbye for now.